Government prosecutors now appealing the special master ruling from Judge Aileen Cannon. They say that they don't want anybody meddling in their investigation of Donald Trump, the former president. Today, we're going to take a look at the 11th Circuit Court of Appeals, which is where the government appeal landed. There's a 29-page document that we'll read through. This is the basis for why the government says that the special master shouldn't have possession over, if you remember, those 100 very confidential documents that they said were the end of America if somebody sees them, so on and so forth. So we'll get into that. But first, I want to make sure that we understand sort of what they're appealing, which is the special master, because the special master, Raymond J. Dearie, was already appointed, and we talked about him previously on this channel, but they also now have him taking action. The judge ordered him to do certain things, and Raymond Dearie said, perfect, I'm ready to go. And so he's already issued an order. So while the government is appealing this and saying, we want you to undo the appointment of this special master, the special master is already off to the races. And so let's take a look at what the special master is doing before we take and see what the Court of Appeals is debating. This was filed on September 16th. It is one page, Donald Trump versus United States of America. This is the special master order. And look who signed off on this thing. It's Raymond J. Dearie. Normally, on this case, we're used to seeing Judge Aileen Cannon, United States District Judge. But this one's coming from another judge. He's from the Eastern District of New York, I believe. And now he is signing off on an order going to the same parties, going to Trump's defense and the government prosecutors, signed in Brooklyn, New York, which is where he is based. And here's what it says. It says, okay, Trump, you lawyers, and it says government prosecutor, you lawyers, counsel are directed to appear before the undersigned, before me, in courtroom 10 of the Brooklyn Federal Courthouse on Tuesday, September 20th at 2 p.m. for a preliminary conference in the above captioned matter. And show up here in my courtroom, right? Don't call in, no virtual, nothing, none of this stuff. And remember, the other case is actually taking place out of the Southern District of Florida, right? They were in Florida in Judge Aileen Cannon's courtroom. So he's calling them all the way up to Brooklyn, making them haul their butts all the way up north. Before the meeting takes place, which is on Tuesday, counsel are invited to submit proposed agenda items for discussion by docketed letter to be filed by the close of business on Monday, September 19th, 2022, which is today, the recording of this video. And so the prosecutors at the time of the start of this show, they have submitted their memoranda, their proposal for the agenda for the following day. And here we have that pulled up. Filed September 19, 2022, coming out of the National Security Division from the U.S. Department of Justice. 113 pages? Oh my gosh! Well, obviously, we're not going to be able to get through all of that here today, but let's see what is in here. This is going over to Judge Raymond J. Dearie out of the Eastern District of New York. And they say, hey, Judge, you wanted an order. You told us to send you over a proposed agenda. And here's what we've got for you. Dear Judge Dearie, pursuant to your order, you invited us to submit a proposed agenda for the preliminary conference held on Tuesday, September 20th. The government submits the following agenda. And the proposed agenda is as follows. Number one, government says that we would like to talk about the precise mechanics of document flow. And remember, in Judge Aileen Cannon's order, we talked about this at length. It was essentially the government has the documents. They send it over to Trump's lawyers. They look at the documents. They make a spreadsheet of the documents. They send the spreadsheet back over to the prosecutor. The prosecutor looks at the spreadsheet. They say, okay, row 1 through 5. Okay. They say, we agree with you on this one. That's executive privilege. We agree with you on that one. That's not executive privilege, but we disagree with you on this one. You say it's executive privilege. We say it's not. And they bring that one that is a disagreement over to the attention of the judge, right? This process back and forth. And so it was sort of laid out for us, but certainly there's going to be more mechanics here. Like the government prosecutors are going to be like, well, wait a minute, what email does it come from? And you know how prosecutors are. They're just a pain in the butt and they're just whining all the time. And so they're just like, well, I don't know what happens if we send it to this email, or how length of time till he responds. And there's total dorks. So they want to know the precise mechanics of the workflow. All right. Number two, aspects of the order appointing you as special master and discussion of the draft case management plan provided by the special master to the parties on September 19th. So they're like, hey, judge, the judge gave you all of these powers in their special order, master order. And we have questions about, what your powers are. And so we want to discuss this with you on that day. And then number 3, they also want the next progress review and the status conference. So probably, schedule some dates and get things in alignment. Now, they say the government elaborates on each one of these topics below. Okay, and so this is short before they're probably slapping in a whole big, addendum of documents or supplements to the end of this thing. So we can go through this. It says, the government elaborates on each of the proposed topics below. Now, the precise mechanics of the document workflow, they're like, all right, hang on a second here. Judge, they say the appointment order contemplates the review of approximately 11,000 documents that we took through a court-authorized search warrant. It says that all of that's going to be done shortly after Thanksgiving. Footnote 1. They're saying the government applied to the 11th Circuit for a stay last week, and the plaintiff's response is due tomorrow at noon before the master's preliminary conference. If the 11th Circuit stays Judge Cannon's order with respect to the documents, then the special master will not review the documents with classified markings, okay? If the 11th Circuit does not stay the review of the documents, the government will propose a way forward, right? And remember, the reason why the government was filing this appeal was because the judge said all the documents are going over to the special master, including the 100 confidential documents that the government was freaking out about. The 11,000 documents, they're like, whatever, we can give or take those 11,000 documents. But those 100 documents we're very concerned about. And so we want this to be resolved, right? We want to get more details of this. And so they're asking the special master to detail his plan based on what happens with the special master appeal. Okay, so we've got these two things, so it's hard to keep track of both of them. But this is the agenda that the special master is going to attend to tomorrow. And there's also an appeal that might implicate how the special master handles everything, right? So there's multiple layers going on here. So he continues. He says, now, the review process generally requires the plaintiff to categorize the seized materials as presidential records or personal records, assert the privileges that they believe apply, record those in a log, and then send those over. For its part, right, the government is going to review Trump's position, agree or disagree. Any disagreements are going to go back to the special master. And then there's going to be recommendations to the judge, okay? They look at the spreadsheet, they fill it out, they send the spreadsheet back, they fill it out, disagreements, they go up to you guys. So they say to implement the appointment order and to complete the special master review process in an efficient and timely fashion, the government proposes that a third-party vendor be engaged to scan, host, and go through all of the documents. They want this company called a relativity platform here. So they want each private workspace. They want this company to come in and scan all this stuff, basically. The relativity document review platform is familiar to both parties, going to be secure, and we can all do our discovery on this document. To provide documents for the Trump team as soon as possible, the government is prepared to provide the seized materials, not including the filter materials, to the vendor, and we can start the process soon. The government proposes that the document review vendor batch out the documents on a rolling basis, logging 500 documents at a time. You see non-documentary items will be made available to Trump's counsel. And so it's all of the mechanics. Not that interesting. Once the parties agree that the certain items are personnel records, then the court has made the determination. The government will then return the items that were not commingled with the classified documents by stipulation. The government will maintain a control copy of the returned materials. Right. So we're going to see if Donald Trump and his team has filed something that should have hit the docket. So we'll take a look at it as soon as we're done here. But they may disagree with this, right? Because a lot of this actually is important because it has to do with possession of the materials. The government says that everything that we're talking about is theirs. They have a possessory interest. If it's confidential, it's theirs. If it's anything that's a presidential record, it's theirs. And so they're basically saying that they should be in possession, physical possession of these things for as long as possible. They don't want Trump to have it at all. Now, this is, in my opinion, something that is the key issue, right? This is the issue that is the crux of the whole thing. That hasn't been litigated yet. Nobody's proven one way or the other whether it is a presidential record or a personnel record or whether it is confidential or declassified. We don't know those things. Now, other aspects of the appointment order. The prosecutors are proposing, they say the government strongly urges the special master to consult with NARA when it's making its determinations. All right, so they're saying, Judge, there was a little bit of gray area here. The order said that you can permit the special master to consult with NARA, but we are strongly urging you to consult with NARA, right? Because NARA is on team Biden, team DOJ. The Biden administration wants to take out Donald Trump. They've done that through a documentary proceeding. They basically waived executive privilege. NARA said you wanted the records back. The White House waived it. We covered this previously. The judge found Aileen Cannon in her own filings that Biden approved this, authorized the FBI to go get these documents back. We've covered that previously on the show. So if all that's happening now, right, the government strongly urging the special master to consult with NARA. Why? Well, because NARA is in the tank. And the order only permitted the special master to do it. The special master is not obligated to go to NARA and get their back and get their conclusion for how to categorize these documents, what document bucket they fall into. They say, the prosecutors write, the government is also prepared to address any questions the special master has for the parties on the order. They're asking about the next progress review. They say for at least the first few weeks as you're going through this stuff, Mr. Special Master, the government proposes that the master conduct weekly reviews with the parties by video or audio conference to resolve any problems. The government is also available to meet in person if the special master prefers. They say attached to this letter and pursuant to this order, the government provides a search warrant, executed and redacted public versions of the underlying application materials. Also, please review the following remainder of these documents. Here's the search warrant. And we covered basically all of this. Okay, so yeah, this is the entire, they're supplementing their filing with basically everything else that they filed in the case. Okay, because it's in a different courtroom. And so they're adding basically the entire case file. And so we're going to just scroll, the affidavit, the application for the warrant, all of the sealing requests. And then we finally get to the exhibits. Yeah, and then these are all the letters, right? These are the letters. And so we've covered, I'm going to guess this entire, applications. Let's see what's at the very end here. All the way at the bottom of page 113, certificate of services, acknowledgement. And then this was some protective orders. And yeah, okay. So the rest of it, sort of mechanical stuff, protective orders for the debates that are going to be taking place sort of under the confines of special master, right? When they're talking about certain things, they don't want anybody who's involved to be able to go and communicate these things. And so they're going to be, issuing protective orders. So 113 pages. That is the proposed agenda by government prosecutors that was requested by Raymond J. Deary, the special master. And while we're here, let me actually see if there has been an update, because Trump's team should have filed something. And so let's see if we have those available while we're here. He had not filed anything, but business should be closed. And here it is. They did file. So take a look. We've got here notice by Donald Trump regarding the order, regarding the proposed agenda, filed by Lindsay Halligan. Let's see what Lindsay Halligan has for us here. And so we'll make sure we get our nice red pen out and dig into this one. Donald Trump's defense team filing their proposed agenda for the special master. They say, Dear Judge Deary, on September 16th, Your Honor invited the parties here to propose an agenda for the meeting. And this afternoon, Your Honor provided the parties with a draft case management plan. And by way of responding to the invitation for these documents, here is our plan as follows. Trump and his team are stating the following. They say the district court's order indicates that the presumptive end date of November 30th is set in stone. They say the proposed calendar circulated today by the parties only compresses the entirety of the inspection and the labeling process to be completed by October 7th, they say. We respectfully request that all of the deadlines can be extended to allow for a more realistic and complete assessment of the areas of disagreement. Oh, very interesting. Okay, so government prosecutors, they want this thing done now. They want it done immediately. They were so unhappy that there was a delay at all. They were saying that, Judge, you're stopping our criminal investigation of the former president. America's going to melt down. How dare you? We're appealing it, which we'll get to in a minute. But in the meantime, they said, can we please just at least continue on with these 100 documents? And the judge said, well, no. Special master is being appointed anyways. So they want to rapid fire this through. Trump's team says, well, what's the rush? We got a lot of areas of disagreement. I'm pretty sure that when they categorize something as executively privileged, we're going to say, no, it ain't. And if they say it was confidential, we're going to say, no, it isn't. So Trump's defense, they say, Judge, along those lines, so that we can work all of these things out, and to assure the court that the parties are operating with the appropriate urgency, we would suggest a status conference in roughly 2 weeks to gauge how long the inspection process and the rolling categorizations are taking, and to take a fact-based measure of the likely duration of the events. Now, you see how the defense attorneys work versus how the prosecutors work. Okay, the prosecutors are a bunch of dorks over there, and these guys are like, roughly 2 weeks. What's good? 2 weeks from now. Pick it. Friday's good for you. Just put it on the calendar, and we'll be able to sort through this. We'll take a fact-based measure, likely duration of these events. Okay, yeah, we'll just kind of rolling categorizations. We can work through it. They say, in the meantime, though, we provide below an informal grid of party obligations under Judge Cannon's order and possible deadlines to be discussed tomorrow or soon thereafter. They tell us the responsibility is that the government provides copies of the filter team documents considered possibly privileged. That has already been done. So it sounds like the Trump team has gotten copies of those documents that may have been privileged, already been delivered. Government prosecutors providing copies of all other documents except those marked as classified, which is basically the biggest bulk of these documents. Remember, there was 11,000 documents seized. Only a tiny fraction of those were confidential problematic documents. And so a big portion of those apparently are still being analyzed. Government making available documents marked classified. They write TBD, TBD. They write next week, maybe? Next week? How about this one? Plaintiff, meaning Trump, creating a privilege log. They say TBD. How about 2 weeks? How's that sound? And how about Trump to categorize 4 categories by mid-October, special master to provide logs to the DOJ. They say, well, whenever that's ready, that's a special master decision. And then they say the special master can make a report late October. We get deadlines early November, mid-November, late November, then any hearing on Rule 41 or related filings. Late November, right? They're like, man, we just push this on back. What's the rush? Plus, there's going to be holidays. It's going to be Christmas time. The kids are going to be on break and anyways, and so there's no real hurry here. Trump's team, they say, finally, although we recognize the time for full objections on the draft plan is not today, we are concerned, right? We're not supposed to be objecting, on these things. They say we are concerned that it contemplates resolving issues that were not raised by Judge Cannon in her order denying the stay or oral argument. Okay. And this is I was waiting for this. This is where we're going to be talking about scope creep, right? Judge Cannon appointed a special master and defined the boundaries of what this special master can do. Said, this is your hula hoop. This is your jurisdiction. This is where you live. And you have to live in there. You don't get to just do whatever you want all over the place, right? You're not the judge of the case. You're a special master, so she's maintaining control and jurisdiction over this. Now, what the government is going to want to do is try to commandeer the special master and start to have the special master exceed that scope and start to do things and answer things and sort of extend into other areas. And one of those other areas might be about consulting with NARA, for example, like we just talked about, right? The judge said they can communicate with NARA. The government came in and said, we strongly urge you to do it. Like, we can't order you to do it, but we strongly urge you to do it. Trying to expand that hula hoop a little bit, expand that scope. And Trump's defense is trying to say, hold on a minute. You don't even have, Mr. Special Master, you don't even have the power to do that. Even if you wanted to, you don't have the authority to do that. Saying we're concerned about this, contemplating issues that were not even raised by the judge. Specifically, Judge Cannon, writes Trump's defense, was aware of the likelihood of eventual litigation and a process where a special master would evaluate claims and make recommendations to the full court. While Trump is, of course, willing to brief anything ordered by the court under the auspices of a special master, right? We're willing to brief things like you want us to brief here, sir. We are concerned that the draft plan that you've given to us directs Trump to address whether litigation should be litigated under another case. In other words, plaintiff respectfully, they say, sees no indication that the district court planned to carve out related litigation for a merits determination by issuing magistrate for the warrant in question. Right, saying that you're asking us to sort of go and open up this entire box about the justification of the original warrant and all of this other stuff. Well, that's not what we talked about. So they're saying, Judge, Mr. Special Master, this is a little bit outside of what we're supposed to be talking about here. Most importantly, none of the district court's orders have ever indicated that this was even in consideration. Trump's defense says, similarly, the draft plan that comes from you, Mr. Special Master, requires that Trump disclose specific information regarding declassification to the court and to the government, saying that you want us to communicate that we have declassified this or we have not declassified that. They say, we respectfully submit that the time and the place for affidavits or declarations would be in connection with a declassification motion, a component of its argument for the return of property, right? Saying that's not ripe yet. And remember, this is something that the left has been trying to make arguments about. Guys like Weissman and many others over at MSNBC have been saying, wait a minute, why hasn't Donald Trump proven his innocence yet? Why hasn't he, if he really did declassify these documents, why hasn't he provided evidence? Where's his signed order? Where's his recorded statement that he actually did all of that stuff? They're saying without that, he must be guilty. In other words, they're taking the burden of proof, which used to be in this country, for the government to prove, and they're shifting it over to Trump because they hate him so much they don't care about, thousands of years of Western judicial tradition. So they are instead saying, no, he has to prove his innocence by confirming that he actually did declassify these things. When he didn't raid anybody's home, he was sitting there at home and they raided him. The presumption of innocence lies with him. So Trump, in his defense, they're saying, Judge, it's not ripe for us to make those claims because we're not at Rule 41 litigation. And if you make us do that, they say the special master process will have forced Trump to fully and specifically disclose a defense to the merits of any subsequent indictment without a requirement, even in the district court's order. Okay, remember now, we are literally only talking about the documents that the special master now has possession over, right? They were with the DOJ. They're over with the special master now. This is about a limited, very limited juncture in this case. Donald Trump has not even been indicted yet. So making him now show all of his defenses about declassification or personal records or anything is not ripe yet because he has not been indicted. He still maintains all of those presumptions of innocence, and the judge in her underlying order from the district court didn't even require the appointment or the mandation that the special master go and investigate these claims at all. Wasn't even required. So Trump's defense, they say, in short, Trump has every interest in expeditiously moving forward on the document review, the characterizations, and any ensuing litigation. And with the government's help in terms of access to those materials and clearance for Trump's lawyers, we believe that the parties can meet the expected deadline of November 30th. While we have concerns about the inclusion of two aspects of the draft plan, timing of any declassification disclosures and briefing regarding the reversion back over to the magistrate judge, we are otherwise in general agreement with your honor's proposed sequencing, but suggest addressing the potential deadlines at tomorrow's status conference. Thank you for the opportunity to present some of these issues by way of assisting with tomorrow's agenda. Sincerely, James Trusty, out there at the DC office at IFRA Law. Also signed by Evan Corcoran, Lindsay Halligan, Donald Trump lawyers, and sent over to U.S. government prosecutors. That's Trump's agenda going over to the special master. They are meeting Tuesday to hash through these things. And Special Master Raymond J. Dearie will, of course, have more guidance on what is going to be required of the parties after that hearing. We'll get some more updates on that. So that is the Dearie order. That was the prosecutor's response, proposed agenda. That was Trump's proposed agenda and response. But that's only one portion of this whole thing. Government prosecutors appealed Donald Trump's special master win over to the 11th Circuit, and they filed a big 29-page brief. You can see that it landed on the 11th Circuit's court docket, and this is what it looks like when you go over there. Filed back in August, notice of appearance, all of this originating from Judge Aileen Cannon and the same U.S. attorneys that we've come to familiarize ourselves with. People from the National Security Division, people like Bratt and others are listed here. Actually, this is by Juan Antonio Gonzalez is the lead lawyer here. From Trump's team, we see the regular team there. Christopher Kesey, James Trusty, Lindsey Halligan, and others. But they filed this appeal because they do not want the special master to get involved. They don't want any third parties meddling with their investigation of Donald Trump. 29-page appeal by government prosecutors in the case Donald Trump versus United States of America. Remember, they're appealing the motion for a partial stay pending the appeal. They're saying, we don't think a special master is warranted at all. And while we're appealing that issue, we want those 100 documents that Judge Aileen Cannon ordered be withheld from the government investigators. The government prosecutors want that undone. They want those documents back. Here's Jay Bratt, along with Julie Edelstein and others, Juan Antonio Gonzalez, Matthew G. Olson, who we've talked many, many times about on this show, Assistant Attorney General, one of the individuals who has made his entire career on the back of homegrown extremism. These are the people that we're talking about. Motion for a partial stay pending appeal. They say, here's the certificate of interested parties that have been notified about this. And so they're just communicating that everybody who has an interest in this appeal has been properly notified. Take a look at all of the underlying parties that were labeled in the original underlying case. AP, Bloomberg, you got Jay Bratt, of course, CNN's here. Aileen Cannon, the judge, CBS, Evan Corcoran, Raymond J. Dearie's notified, Julie Edelstein's a prosecutor, everybody, Halligan, Trump defense, NBC, Raj K. Patel was a pro per filing there in the prior cases, New York Times, right? They're all there saying, Judge, we're notifying everybody in that underlying case that we are appealing. Dated September 16th, filed in the 11th Circuit Court of Appeals. Here's the introduction and the summary. They say, Judge and judges, in the 11th Circuit, the district court has entered an unprecedented order enjoining the executive branch's use of its own highly classified records in a criminal investigation with direct implications for national security. Extremely dramatic. Now, unprecedented is the appointment of a special master. Okay, it's a referee who got appointed to oversee what's happening. Unprecedented to do that. And this is the point where I was explaining that the government has presumed the outcome on this. They've already come to their own conclusion. They say that the executive branch, meaning the presidency, has been enjoined from using its own highly classified records. That is the subject of the debate. Donald Trump doesn't say that. So they are supposing the conclusion. They write, in August of 2022, the government obtained a warrant to search Trump's house based on a judicial finding of probable cause, saying that there's going to be the end of America. We recovered 100 records of classified markings. Some were extremely restricted. 2 weeks later, Trump filed action here in suing us, demanding that a return of the seized materials, demanding a special master review, an injunction barring the government from their criminal investigation pending the outcome of the special master review. And they're so concerned about this because it's going to impede their work. And they really got to get this in before the election. Although the government, they say, this is appealing to the 11th Circuit, prosecutors say, although the government believes that the lower court, Judge Aileen Cannon, fundamentally erred in appointing a special master and granting this injunctive relief, the government seeks to stay only the portions of the order causing the most serious and immediate harm to the government. And do you believe that? Do you really believe that? They're like, well, we were going to win everything, but we're only going to fight on these two pieces, on these two fronts. We were going to win everything else, but forget all of that other stuff. So they're going to leave all of that behind, and they're only going to focus on these two areas. One, restricting the government's review and the use of the classified marking documents, right? So just putting that in the one side. And number two, requiring the government to disclose those records for the special master process, right? So they're limiting this intently to only those 100 or so documents. That's the only basis of this appeal. And they say this court should grant that modest but critically important relief for three reasons. So it feels to me like they're sort of abandoning some of their efforts here. Because if you've been joining us here on this channel covering all of these motions, the government sure had a lot of bravado in their previous filings, didn't they? Remember, they gave Judge Aileen Cannon kind of a deadline. They said, hey, you either undo what you did by this date, otherwise we're going to appeal it to the 11th Circuit. And they did. Judge Aileen Cannon said, well, here's my opinion. And they said, all right, well, we're appealing it. But we were listening here, reading through the motion, and we said, well, that's kind of bold. Demanding the judge do something or else? Okay, it's like we're going to your manager type of argument. And they did that. But now they're abandoning all of that. They must really, 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 really want these 100 documents back. There's something in there that they don't want going to this special master. Let's see what the arguments say. They say first, the government is likely to succeed on the merits. Same argument we've heard many times. So let's see what we can glean from this. They say the district court, Judge Aileen Cannon, appointed a special master to consider claims for a review of the documents. But they say Trump has no claim for those records, which belong to the government and were seized in an authorized search. This is that possessory interest. They say those records are not subject to any possible claim of attorney-client privilege, and neither Trump nor the court has cited any authority suggesting that a former president could successfully invoke executive privilege to prevent a former executive privilege or another executive branch from reviewing its own records, citing Nixon. Now, again, right, Judge Aileen Cannon addressed this point, and she said that you could interpret it differently and that it wasn't as clear-cut as they're implying here, and I agree with her. Second, they say, the government and the public would suffer irreparable harm if they don't get those documents back, right? Those 100 documents, if they don't get them back, we're all going to die. The district court recognized the government's overriding interest in assessing and responding to the national security risk from the possible unauthorized disclosure of the records bearing classification markings. And again, nobody knew anything about these documents until the DOJ got their hands on them. They were sitting there quite peacefully and patriotically in Trump's closet in Mar-a-Lago. And then suddenly, as soon as the FBI and the DOJ got their hands on them, everybody knew what was in them. Everybody. It's leaking over to the Washington Post. They have like a straight line access to the Dropbox folder. The court, but now they're saying, oh my gosh, now if we don't get those documents back, if we can't process those 100 documents, we're all going to die. The court thus stated that its order was not intended to impede any ongoing investigations, but they write, as they're appealing to the 11th Circuit, but they say, hey, but as the head of the counterintelligence and FBI division explained in a sworn declaration, and we read that was Alan Kohler's declaration saying, it's going to be impossible. America's over. He explained that a criminal investigation is essential to mitigate national security risks. And so the court's order, Judge Aileen Cannon's order, hamstrings that investigation. And it places the FBI and the DOJ under a threat of contempt that the court later, if they later disagree. It irreparably harms the government by impeding their criminal investigation. And they say, third, the limited stay would impose harm on the plaintiff, no harm on Trump, Okay, so if you give those documents back, those 100 documents, if they go back over to from the special master back over to government prosecutors, they say it doesn't hurt Trump. They say it would not disturb the special master's review of all of the other documents, including the attorney-client privilege stuff, nor would it infringe any interest in confidentiality. The government's criminal investigators have already reviewed the records, and the district order contemplates their review for national security purposes. And you say to yourself, wow, that's really a really interesting interpretation. They say if they have evidence that is, in their interpretation, theirs, it's not going to harm Trump. But if their interpretation is wrong and that evidence is Trump's, right? If it is his materials, if it is declassified, if it is personal records instead of presidential records, they don't give us a basis for any sort of out on that. I guess in that case, wouldn't Trump be hurt? Wouldn't he be harmed? But they're not accounting for that at all. Finally, they write, because the government and the public will suffer irreparable injury absent a stay. Again, whatever that is. A nuclear bomb's going to go off. How are we all going to die? I don't know. But absent a stay, if the special master, who again is not going to do anything with these documents, right, other than just review them. It's Raymond J. Deary. He's like 80 years old out of the Eastern District of New York. He's been doing this for 200 years. So I don't think he's going to be a spy who turns this over to, what are they worried about? North Korea, Saudis? I don't know what they're all freaked out about, but apparently these nuclear codes are going to somebody. What is the irreparable injury? We don't know. But they give us the rest of the background here, and you can see there's going to be a big statement. Let's take a quick look at this. Yeah, a lot of this is going to be sort of stuff we've already covered here. They're giving us a background on what happened with Trump and Mar-a-Lago. They talk about the proceedings, which we've covered at length. We've covered all of the arguments. Remember, they've made the same arguments about the classification markings. The crux of this is that they own the property. And if the government owns the property, Trump really loses the ability to make much arguments. But as Aileen Cannon said, that is presuming the conclusion. All right, so let's see how they're wrapping this up here at the end. The conclusion: the district court's order should be stayed to the extent that it enjoins the further review and use for criminal purposes, and that it requires the government to disclose those records to the special master. They're asking the appeals court, don't give that stuff to the special master, or if the special master already has it, give it back to us in the government. Certificate of compliance, certificate of service, both there. That is the appeal. And Trump in the Court of Appeals has been ordered to respond to this by 12 p.m. on Tuesday. So Trump and his defense team are going to have to rapidly come up with their brief to the Court of Appeals, and we'll see where that goes. Now, we also had a very interesting filing here. There was a motion to intervene filed by the United States Treasury Department. The Treasury Department, what the heck are they involved in the Donald Trump Mar-a-Lago search warrant saga? How did that happen? Well, here's what it looked like. The U.S. Treasury motion to intervene. Oh, this is weird. It's a 2-page document. It's in the United States of America versus the sealed search warrant. And this is the case that was signed off on by Judge Reinhardt. This is the Mar-a-Lago search warrant case, remember, out of the Florida district for the Southern District of Florida. So the U.S. Treasury files a motion to intervene. It says the U.S. Department of Treasury through the U.S. Department of Justice and the U.S. Marshal Service, wow, have arrested, seized federal securities containing sensitive documents, which are subject to the defendant's sealed search warrant by the FBI arrest. What? See attached arrest warrant under the National Security Act, U.S. Code 3162. Pursuant to 24A1A2, the U.S. Department of Treasury must intervene to protect the interests. Dated by the U.S. Department with 2 N's on there of the Treasury intervenor, dated September 8th. Came in priority mail, U.S. Southern District Court. Looks like a FedEx package. Came in via certified mail. Somebody paid $16 and sent that into the court. Okay, so the U.S. Treasury Department is intervening against Trump? Well, this is weird. All right, here's the attachment they sent over. U.S. Department of Treasury, the defendant is seized federal securities. Serve at CNN Center in Atlanta, Georgia. Department of Treasury, Brent McIntosh. All of these documents, Linda Banks, title person, U.S. Department of Treasury is a subpoena warrant. This was filed, I don't even know, really what we're looking at here. Ashley Poor, office manager from the U.S. Marshal's office, filed in the clerk's office, July 29, 2021. What is all this? I guess it's the U.S. Department of Treasury. Okay, so all of that got filed in the search warrant case. Now, as you can probably guess, the U.S. Department of Treasury did not actually file this. All right. The government confirmed accordingly. Prosecutors said, Judge, I don't know what that was, but the United States of America hereby moves to strike docket entry 128. That purports to be a motion by the United States Department of the Treasury to intervene in the instant matter. The United States has confirmed that the pleading was not submitted by the Department of Treasury, but rather mailed to the clerk of the court by someone not associated with the government. Signed here by Juan Antonio Gonzalez. So another very interesting motion in this case. We've seen a couple of these. But here, the government confirming the Treasury is not yet going after Donald Trump. And so that, my friends, is the update on the Donald Trump saga. We've got a lot more to cover. There's going to be a big hearing tomorrow. Well, several of them are due tomorrow. We've got the special master hearing that's going to be taking place. We'll have a formal agenda, probably have a calendar and more details on what's coming out after that. But we also have a deadline by the Court of Appeals. So Donald Trump and his defense lawyers, his appeals lawyers, more specifically, are probably typing away like mad, trying to get their brief ready and submitted because they've got a deadline coming in hot Tuesday at 12 p.m. And so we'll, of course, cover that. I'm sure we'll have much more of that tomorrow. Thank you for subscribing. Thank you for supporting the work here, joining us over at our community at watchingthewatchers.locals.com or becoming a member on YouTube. Either way, I appreciate your support.